SJC-13770, Commonwealth versus Raymond J. White.
Attorney Neves.
Good morning. Catherine Neves, on behalf of Mr. Raymond J. White, the defendant appellant. I'd like to note that members of Mr. White's family are here in the court with us this morning. Mr. White was convicted of 2 counts of first-degree murder more than 53 years ago in 1972 and was sentenced to death. Until now, he never had a direct appeal through no fault of his own. Thanks to a jailhouse lawyer in 2014, the single justice in 2016, and this court's 2018 decision, he is here before you today for the functional equivalent of a direct appeal, including 33E review, which the court took a special care to make sure that he would have that protection when the case made its way back to you. Because he never had his direct appeal and it was not a counsel decision on his part or a strategic choice on his part, but it was seriatim neglect of 3 lawyers over the course of decades who failed to do anything to protect his right to a direct appeal, Mr. White is entitled to the benefit of all law that is developed in the decades since he has been incarcerated for first-degree murder.
Well, what do we do about the fact that he was, he had escaped and was out on his own for 8 years?
Yes.
Won't that have an effect on calculus? And if not, why shouldn't it?
I think it does not, and I think for a number of reasons. First of all, the motion judge below did find that the escape had an effect, but he was not the trial judge, and he did not conduct an evidentiary hearing. So this court will make its own assessment of that de novo because it's in as good a position as the court was below, and it has before it the motion for new trial and all of the documents that were filed in support of the motion for a new trial.
But isn't it actually just a legal question as to how?
That's just the start of, yeah, that is the legal question. So, but it is based on what he had a record before him that wasn't just the trial record. And before him.
So no deference is what you're arguing.
No deference.
Like. But I guess to Justice Wolahojan's question, why would the defendant get the benefit of the changes in the law after he escaped?
He escaped. So first of all, this court's precedent in Beauchamp is the critical case. And in Beauchamp, the defendant went on escape, never appealed, and went on escape, came back and asked for his appeal. The court said, we don't think he should get the benefit of changes in the law where the only reason for the delay was his escape. In this case, Mr. White sat in prison from 1972 to December 1980, and 2 lawyers failed to perfect his appeal. They did nothing. His right to a direct appeal was lost before he went on escape.
Well, excuse me, but we're not talking about the period up until 1980. We're asking about the period after 1980, and that he is different from Mr. Beauchamp. Mr. Beauchamp escaped almost immediately after his conviction, so there wasn't such a period.
Correct, but what the court said was the only reason for the delay in the direct appeal was his escape. That is not the only reason here.
So what's your best argument for saying that he should have the benefit of all of the changes, even during the time that he had been away?
Well, I think the best case is this court's 2018 decision itself, in which the court made no reference at all to the escape, possibly because the single justice herself said, because the Commonwealth made that argument below, and she specifically said, he has not waived his right to plenary review because of this escape.
And that's
between
fair.
1980 to 1980.
He has that.
Right.
Right.
Right. I mean, So, and he's back for decades longer. So the only reason Beauchamp, the notion that somebody does not get plenary review on appeal.
I'm not saying he doesn't get we've already decided he gets 33E review, right? So the question
Correct.
is whether he gets the benefit of changes of the law post-escape. Those that aren't specifically retroactive.
I think the court the single justice said he did not waive, it's not a done deal. I think
The single justice in the appeal in this case had nothing to do with, or did not address, I should say, what law applies. It had to do with whether or not procedurally he gets 33E review, correct?
no, it was whether he would have a direct appeal
Right, and plus,
directly to this court.
plus 33E
And Justice
review.
Botsford held that his escape did not waive any right of his to have that kind of review.
We should probably get to the substantive arguments rather than.
Well, there's a lot to this case, as the court knows.
Let me ask you a specific question on, as I see the issues raised, what struck me on the felony murder instruction, and the judge improperly recited the evidence and said there was a robbery here. But where it wasn't objected to, when we were looking at substantial likelihood of miscarriage of justice, here there was no dispute there was a robbery. The dispute here was the identification of the perpetrators, correct?
That is correct.
So how do we get a substantial likelihood of miscarriage of justice given that?
I think it wasn't just a recitation of evidence. It was the statements that, well, I don't think I really need to do much here, given that the defendants didn't really make any arguments or present any evidence that there wasn't an armed robbery. I mean, that's the thumb on the scale that kind of takes, you still have to define the elements.
I agree with you. It was a completely erroneous instruction.
So I think that's where, and I think honestly, most of the issues, including this one, in which the court said, well, and you focus on, did Reuben Lindsay, identified him, he knew him, you think about that. Just the whole, it basically, along with, and I think this goes back to the idea of if you don't think he gets the benefit of law because he escaped and he sat for decades longer after that and had no assistance with subsequently appointed counsel, the reasonable doubt instruction given was plainly deficient. It's retroactive on collateral review. It can't be waived. You can't have a conviction based on less than reasonable doubt. And in this case, the instruction has none of the language that was saving language. There wasn't even moral certainty, but moral certainty was an issue only because if it didn't have language of subjective near state of certitude. There's nothing in this instruction that informs the jury of how high the level of proof must be. Instead, the court defined a reasonable doubt as a doubt based upon a reason, which this court has disfavored because the correct instruction is a doubt based upon reason, and making it a doubt based upon a reason shifts the burden to the defendant. And the other disfavored explanation, these are the only two really, other than to say proof beyond a reasonable doubt isn't 2 + 2 = 4, was beyond a reasonable doubt is the kind of proof you want when you make decisions in grave affairs in your life. Also completely disfavored because we all make decisions on grave affairs with far more doubt than beyond a reasonable doubt for a conviction, and this court has stated so in many cases cited in my brief. So,
well, in fairness, a lot of those cases involve situations where trial judges named specific examples, like buying a house, that the court has said trivialize the standard. Are you aware of a case that, like this one, there were no such examples, and yet the court found reversible error, but just based on saying that it was the kind of decision, grave affairs, et cetera, language?
I would say that off the top of my head, no. I do recall there reading cases, one or two, where they said, you know, especially where you give the examples. I can check and write a letter, but I think one of the cases I cited in my brief just said it's disfavored, because the idea is that people who make mistakes in grave affairs, every grave affair you can think of, can often undo them or fix them. But a conviction, convicting another person of a crime, it's a level of proof unseen anywhere else. You know, it's up here. It's 2 + 2 is 4 is up here, but reasonable doubt, proof beyond a reasonable doubt isn't that, you need a subjective state of near certitude, an abiding conviction of proof beyond a reasonable doubt, something that settles the hearts and minds of a person seeking the truth. A strong probability, even if, you know, a good probability, it's not enough. You know, so there was none of that language here. There was, you know, a proof beyond a reasonable doubt isn't a fanciful doubt. It's not the kind of doubt for someone who's just looking to convict someone. There was not one of the sort of saving phrases that this court and Victor v. Nebraska have talked about. And in a case like this, you know, the court has said, in Pinckney, the court said it was structural error, but it's also said that the question is whether it's harmless beyond a reasonable doubt. And that standard is whether the evidence is so overwhelmingly establishing the guilt of the defendant that the verdict could not reasonably have been affected by the erroneous charge. In 1976, when this court decided Mr. White's co-defendant's appeal, the court said the evidence was overwhelming against the defendants. Mr. White was not with them. The evidence indeed was overwhelming as to Mr. Hall. It was not as to Mr. White. So identity of culprits was the key issue in the case, absolutely. Hall testified he didn't know Mr. White. L.C. Clayton testified to the same.
Well, there was testimony that Hall and White, from White's own sister, that Hall and White had been at her place the previous evening, was there not? And that they left together?
Yep.
So,
and Mr. White testified that he left and went home to his mother's house.
Sure, but that's all for the jury to resolve.
Well, absolutely. But the question is was the evidence so overwhelming that you could say that a constitutionally defective reasonable doubt instruction could not possibly have affected the jury's verdict? And in this case, I would say you cannot. The evidence, Clayton said that Mr. Hall went to him, asked for a license plate, told him he was going to do the robbery on Saturday, come to this apartment afterwards to get the money. He never said that there was another person involved. Eyewitnesses testified that one of the robbers got shot and crouched down. Mr. Hall goes to his car. There's blood in his car. They figure out whose car it is because Alvin Whitlow, who's outside and sees the whole thing, remembers the license plate, and they find, and there's
someone who identifies him as being one of the two shooters. He bought one of the guns that was used in the shooting.
There's no evidence that he brought the gun that was used in one of the
I thought he bought the gun.
He did buy the gun. It was a licensed handgun. Yeah. It was his gun.
Did he also buy the ammunition?
He did buy the ammunition.
Bought the ammunition. He bought the gun. He was with the. I'm just to play devil's advocate. I mean,
I gotcha.
There was evidence that he was with Hall immediately before. There's evidence that he was with Hall immediately after. There's evidence that there's evidence of an eyewitness placing him as one of the shooters.
The eyewitness testified that he did not see the faces of the shooters. He saw their backs.
No, he actually testified, I think, directly that he saw them from the side based on where he was located at that inside the store. He said he had a side view and that he, quote, immediately recognized White, who he had most recently seen 3 or 4 days earlier.
He also testified that their backs were to him and that he got a quick side glance and recognized him right away. The question is whether this evidence is overwhelming that he was it's so overwhelming that this instruction that gave no guidance to the jury, along with a joint venture instruction that placed a thumb on the scale on armed robbery, which then made a felony murder conviction over, along with having these defendants sit in a dock, which was unconstitutional in 1970. The Supreme Court held that having people in shackles in the courtroom erodes the
There's a difference between shackles and a dock.
Of course, but not
You just
not
said,
a whole.
you just said shackled. That's not.
I know.
It wasn't shackled.
It's a badge of confinement, and everybody knows what the dock is. The two guys sitting there all by themselves, and everybody knows who they are. I mean, so they're sitting in the dock, and eyewitnesses who could not identify Mr. White were allowed to point at him and say, "Yep, they look like him."
So are you,
Eyewitnesses that were familiar with Mr. White.
Just one, and that's the one who they had their backs to him, and he said, "I knew it was him right away."
And what was their common experience? They were security together?
It was the manager of the grocery store. Mr. White worked there occasionally. And I have to point out that Alvin Whitlow, who was the bag boy who was outside, saw the whole thing. He said, "I saw the holdup. I heard the shots. I never saw either of those people before in my life," he told the police. He testified at trial. The prosecutor encouraged him to point at the people at the dock and say, they kind of look like the guys, the height, the color, the, mustache or whatever. But he said, "But I'm not saying those are the guys in the booth." He had a bird's eye view, and he could be presumed. He had worked for Freedom Foods for a month and a half. So he did not identify him. Reuben Lindsay, who testified, confirmed several times that their backs were to him, but he got a quick side glance. So this is all to say, I'm not saying the evidence was insufficient. I'm saying, is it so overwhelmingly establishing Mr. White's guilt that the reasonable doubt instruction can survive?
can I just ask you about the standard of review on the dock issue? You just said that you think it was unconstitutional as of 1970. So is your position that it's a substantial likelihood for miscarriage of justice because review because there was no objection?
Yeah, I mean, it's 33E review. You're going to review everything for 33E. So
But if it was preserved, there'd be a different standard.
if it was preserved, it would be a different standard. There are a lot of these things that were not preserved. And so,
We also don't know the setup. We don't know what the dock looked like.
no, we don't. I mean, I do know, and I have to be frank, this court continued its practice of, not this court, but the Massachusetts courts, of using a dock until 1979, after the First Circuit said, "Hey, you're not supposed to be doing that." This court made a prospective rule. So I acknowledge all of that, but I also believe that Mr. White, is entitled to consideration of everything that happened at his trial with respect to 33E review and everything that happened with respect to his lawyers and their failure to work with him. And I will say the motion judge below.
And forgive me for not knowing this, but after this court, chastened by the First Circuit, made a prospective ruling, were other cases during that era reversed because of the use of the dock?
I think before you did the prospective ruling, I think it really was the First Circuit granting habeas in Moore v. Pont.
I'm looking at the aftermath, though.
In the aftermath of that, I didn't really see anything. I think because the court made it prospective, I don't know if there were people sort of in that narrow groove. I didn't find any. I could be wrong, though.
I couldn't find in the record the verdict slips.
I will check and get those to you.
I mean, it was clear to me from the transcript that there were verdict slips.
Yes,
So
there were.
I went to
And-
look. I went to look for them, in part because I was curious about the question of what was the theory of conviction. Was it felony murder
Or
or
deliberate premeditation.
correct?
Yeah, and I, perhaps Commonwealth Counsel will have those. I have.
Maybe you can work together
We
to
will,
find that out.
yes, because I have a very abbreviated file I've collected from I mean, I just have what was given to me. And I can't remember. I would have thought I would have included them in the appendix. If
I didn't
had
see them.
So then I probably don't have them. But, so again, I would urge the court that, oh, gosh, I'm out. I would just urge the court, Mr. White is now 76 years old. He'll be 77 next month. He's a quiet man who served his time quietly despite walking off upon urging of a spouse. He lived quietly while he was on escape, worked the whole time. And I would ask the court that to exercise its discretion and remedy the injustice and grant him a new trial. Thank you.
Thank you. Attorney Knight.
Good morning, Your Honors. May it please the court, Aaron Knight on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. I think it's important, Your Honors, to recognize that this is not a case about whether a 1972 murder trial looks modern enough in hindsight. It's about whether after 53 years there's any doubt that this was the man that participated and shot and killed 2 guards at the Freedom Foods on August 14th, 1971. The defendant doesn't put before you anything to negate his guilt, no theories that could exclude him. Rather, the physical evidence, the eyewitness evidence, the ballistics, the money, even his own sister all point in his direction. Even were this court to credit his procedural claims, none of it undermines the reliability of the verdict, which is what Rule 30 review is all about. Starting with the motion judge and his abuse of discretion here, there was no abuse of discretion in any of his decisions below. I do believe that 1980 is where we draw the line due to his escape. I do believe that his escape on the furlough, even under Beauchamp, which I would like to clarify, Beauchamp was reversed because there was also an issue re the self-defense instruction that required retroactivity. I think that played a lot into it. What I would state is that in cases such as, I think it's, I'm trying to remember, Rabowski maybe, there's a couple of them that they state, they don't want to give the benefit when it's the defendant's, something the defendant did. And I understand that this court is looking at this on 33E. I understand that, this doesn't look great from the record in terms of ineffective assistance of counsel leading up to 1980. But what I would point the court to is the Commonwealth's lengthy recitation of what counsel did in this case. I don't believe that the defendant is correct when he said he just learned of his direct appellate review rights in, I apologize, 2020 or 2004 or 2014. Instead, if you look at the record, it shows that he was from the jump aware of his need to direct appeal. Now, even if this court does change or disagree with the motion judge's decision that he's not given the benefit of the law only up until 1980, there's still nothing here that would warrant prejudicial error warranting reversal of this conviction on these facts.
The judge below seems to have, the judge below did, in fact, often rely on the fact that this court had done 33E review of Hall's conviction. That seems to me analytically suspect because the evidence between, with respect to the 2 defendants was different. It had a different weight. And so do you mind addressing that?
Sure, Your Honor. And I'm not here saying that we can rely on that in its entirety. This court will review on its own. However, I would say that the strength of the case as to both defendants was entirely the same in terms of how strong it was. He was with Mr. Hall when Mr. Hall was found bleeding from the gunshot wound. At no point did he leave Mr. Hall's side. He left Nina White's apartment, and she testified that morning. Mr. White left with Mr. Hall to go to the they left together, inferentially went to the Freedom Foods and returned together. They had the money, he was bleeding. The bullets and the ammo came from the defendant. So I would argue that even under 33E review of Hall, though this court was doing just Hall, the evidence as a whole would most of it would also apply to Mr. White, at least circumstantially. And so here, I would say that when this court does its 33 review, quite frankly, whether or not it does it with review of the law up until 1980 or up until now, the strength of that evidence, there is no doubt that this man was a participant in that crime. And that's really what we're worried
So you're not arguing that we should rely on the previous 33E review?
I'm not saying necessarily you shouldn't. I think that you can rely on it in terms of this court has reviewed. And at the time, should this court apply 1976 law, which is when defendant Hall's conviction was affirmed in terms of everything but the death sentence, at that time, these instructions, the doc, these claims that the defendant makes were reviewed on 33 under the law of the time, and we're fine. And I would say that can color this court's decisions should it credit the time of the law for the defendant to be up until 1980. Now, with the doc situation that my sister briefly mentioned, more was prospective only.
We don't know the doc issue was raised in the co-defendant case, right? I know there's 33 review, but how is a judge supposed to?
No, correct. And I
Other
understand.
than the fact that it was common practice, how was the SJC supposed to know that there was a doc issue?
Sure, I do understand that. And to be clear, in Hall's...
Not a great issue for you on collateral, on the use of the co-defendant's 33E.
And that's fine, Your Honor. As I just said, I think the 33E of defendant Hall can color the issue. I don't think it necessarily resolves the issue. This court will look at it. You are already granting him 33E. But I would say that this court does look at everything. And as of 1970, I believe it was, when the federal court started raising that doc issue, it would have been at least out there, right? And this court decided more in 1979, but knowing that this issue was out there and that cases like Walker from the feds, those cases were at least being tried, those issues were being looked at. Now, whether or not the doc was looked at with Mr. Hall, I will say both defendants were in the same position. This defendant was directly identified by someone who knew him previously and his own sister. And the three witnesses that the defendant talks about the identification, two of them said they looked like the perpetrators. One of them didn't ID White at all. Instead, he ID'd Hall. And in reality, Your Honor, and I know that Your Honor may be familiar with previous practices of the doc being a trial judge, everyone's in some sort of somewhat enclosure, right? The clerk's in an enclosure. Even today, when we have defendants at counsel table, the lawyers are the ones getting up. The lawyers are the ones talking to the judge, right? It's not lost on the jury who the defendant is in a case. And so I would say that here, the doc really did nothing to prejudice him, especially where in this motion judge found there's no allegation that he wasn't able to talk to counsel, that he wasn't able to participate in his own proceedings, or that in any way he was shackled or anything like that and the jury could see.
But you got to admit, it doesn't look good. I mean, it's not the same as
But it was...
in the well of the courtroom.
I agree, Your Honor, it doesn't, but it was the law at the time. More does apply only prospectively, and I will say that, Your Honors, again, this trial was not perfect by today's standards.
Was the reasonable doubt instruction erroneous?
Your Honor, I would say that the reasonable doubt instruction was not erroneous for the time, and let me clarify. For instance, this court has affirmed at least 4 times that I'm aware of, and they're all in our briefs, the almost verbatim instruction given by Judge Roy in multiple other cases. I would also point out that even if this court does move on to that harmless beyond a reasonable doubt standard, it's still within light of the evidence. If the evidence is overwhelming, and this is Garcia, Bonds, those cases state that if the evidence is overwhelming, which the Commonwealth does argue here that it is, there's no doubt that this man was involved. If the evidence is overwhelming, that reasonable doubt instruction, which this court has already affirmed multiple times, is not of the error that would flip this case. Even though some aspects of that instruction may be imperfect under today's jurisprudence, Rule 30 still requires prejudice. And here, with the evidence that was given at trial, the fact that the judge gave an instruction that was comporting with the time, and that this court has also found was good enough in multiple other cases, no, Your Honor, I don't believe that it affects this case. Moving on to the armed robbery that my sister brought up, and Your Honor, I would also point out that the instruction in that case also was comporting with the time frame of this trial. Back then, judges were allowed to comment on the evidence as long as it wasn't a biased comment. And here he points out the reasoning for White and the reasoning for the Commonwealth in terms of what the evidence showed. It wasn't so much a comment on the evidence as almost a recitation. I will say that what really matters in that is, did the jury understand that they retained ultimate authority? And here he made that quite clear. And felony murder, yes, it was permissible at the time, but the jury still had to find that it was these defendants. And quite frankly, that was their defense, was it wasn't me. It was an identification defense for both defendants as to all crimes, not just the murder, not just the armed robbery, the involvement, the being there, the being caught with the money. It was identification. And so here, where even if the judge put his thumb on the scale, I would say, of saying that an armed robbery occurred, which, by the way, was not challenged, an armed robbery did occur. No one challenged that at trial. He did tell the jury multiple times that the ultimate decision rested with them and that this was an identification case.
Can I ask you about an evidentiary issue that has been raised? You argue that the testimony of Nina White, that Hall said, if you had done what you were supposed to, I wouldn't have been shot, to White, to which Hall's counsel objected. Mr. White's counsel didn't at that moment object. You've said that was a statement in furtherance of the conspiracy, which obviously requires that the conspiracy be ongoing, which you cite a lot of evidence that it was, but also requires that it actually be further the conspiracy. In what way, and your brief does not identify a way in which that statement furthers the conspiracy.
My apologies, Your Honor. I would state that it's inferential, that it furthers the conspiracy in terms of they are still in the act of covering this up. He is still in the act of, Nina, with Mr. White standing by, is in the act of treating this wound, trying to not take him to the hospital so that he's not found out as having that gunshot wound where witnesses said it would be found.
Indicates that the statement was made during the cover-up. I think Justice Stewart's question was more, how is it furthering the cover-up?
I think in terms of, it's not a direct like, hey, let's do this, correct? But at the
haven't our cases required that? Haven't our cases required that, for example, there was the one where, well, I won't get into examples, but essentially it has to be in furtherance of the conspiracy. That's part of why we view it as reliable.
I apologize, Your Honor. I don't have something right off the top of my head to give you in terms of a case law for that, but I will say that this, as Your Honor noted, the conspiracy was ongoing. It was not done. The police were about to come to the door. Maybe the way that the phrase was, maybe that statement in and of itself doesn't directly say something along the lines of, go hide this here, although we do have that, go hide this in the vacuum. What I would say is that in any event, you review this for whether or not did this matter? And this part of Nina Hall's testimony isn't the only implication of the defendant from her testimony.
It's really important evidence, is it not? Because it's the only evidence that well, there's a lot of evidence, but it's evidence that really squarely ties Hall and White together as the two co-venturers.
I would say that it does, but so does Hall and White leaving her apartment, her knowing they left together that morning, them returning together with the money, the exact bank bags that were taken, with the amount of money that was taken, Hall bleeding and White still accompanying him, telling Nina to go down and clean the blood out of the car so that they wouldn't be found. All in all, Your Honor, whether or not that particular statement matters in the whole crux of this context of this entire case is very, very minimal, with all of the evidence that was presented and the importance of Nina White's testimony in terms of identification. And I would just state that, where it was still, the conspiracy was ongoing, I think that takes it out of the hearsay. That does take it out of the hearsay category. And even if you extricate this statement, the evidence is still overwhelming. Your Honors, I know that this case This case is definitely one of those procedural cases that's a little tricky. I do think that the Commonwealth lays this out in its brief and in its motion for a new trial response. And I urge you to look at the in-depth recitation of counsel and counsel's involvement in this case. What the defendant truly posits here is that he had procedural departures from what would be acceptable today. And here, the remaining arguable errors, even aggregated, don't meaningfully change the evidentiary posture of this case. Rule 30 is to make sure that we got it right. And here, Your Honors can be assured by the weight of this evidence and how this defendant was convicted in terms of that evidence that we got it right. So if there are no further questions, the Commonwealth would rest on its brief.
Thank you.
Thank you, Your Honors.